Sam Seder on the Majority Report. It's a pleasure to welcome to the program Jay Willis. He is the editor-in-chief of Balls and Strikes. Jay, welcome to the program.
Hey, good morning, Sam. Thank you so much for having me.
So we've got this case that was just argued in front of the Supreme Court about the president's authority under the EEIP, the emergency. I can never remember what it is, but it's
me neither. It's fine.
It's an emergency powers that he is contending he has to impose tariffs, and we should say Congress also, or the House, abdicated its responsibility in the passage of the big, beautiful bill, and I think it was, or the continuing resolution the first time around. It was the continuing resolution in March saying we abdicated authority over tariffs until I think it was till 2026 to allow them to escape any responsibility for this. Before we get into the specifics of that case, will you remind us of the arguments that were made and how the Supreme Court ruled when Joe Biden tried to exercise emergency powers under the Education Act to that supposedly, at least we all thought, allowed him to waive or modify loan repayments?
Yeah, I will. And thank you again for having me. And it's been wild to sort of read about this case and listen to oral arguments, I guess it was last week, and think, wait, weren't we just here? Didn't we just figure out what presidents can and can't do? But you're right. In 2023, the court decided the case Biden v. Nebraska about Biden's student debt relief plan. And Biden had grounded his plan in a provision of federal law that allows him to, and I'll quote, waive or modify certain legal obligations during national emergencies. Biden's position was that a deadly pandemic that had ground the global economy to a halt probably constituted an emergency such that he could extend partial student debt relief to a cohort of lower income borrowers. But the Supreme Court, and specifically the 6 conservatives on the Supreme Court, said, nah. And they based their opinion on what they call the major questions doctrine. I want to stress that the major questions doctrine is something that the Supreme Court has created. And what it says is basically, if the president is asserting that Congress delegated to him some power under federal law, that Congress has to be really clear before giving the president power to do basically anything big. Vast economic significance is the court's language. Stripped of legalese, the court just says, listen, Biden for giving student debt relief, too big a deal to be legal. So the question here
can we just stop here for a moment on this?
Sure.
Because the major questions doctrine, I just want to remind people, was made up out of whole cloth. I went to law school for a year in 1990 or 91. I can't remember what it was.
Condolences.
And yes, I've recovered. It took a while. I've recovered. But when I went to law school, we were still almost 15 or 20 years away from the concept of the major questions doctrine for even being in existence. Like, this is so unripe, as it were. And it was made up from whole cloth. This idea of there's no limiting principle to or defining principle as to what major economic implications are, or, I mean, none of it. It all just seems to be basically like it's a wild card or a get out of free jail card where the conservatives just go, we're going to use this now, actually.
And you're right. And that's why it's such a powerful tool in the justice's hands, and particularly in the conservative justice's hands, because here you have, I mean, again, my view is that COVID-19 was much more clearly an emergency than Trump saying trade deficits exist, or Canada ran an advertisement with Reagan that I didn't like that hurt my feelings. That's my opinion. But you don't have to agree with me to see that the framework is really similar. You have a president using kind of unclear statutory language and asserting that to implement a major item on his policy agenda. The difference now is that the court didn't like and didn't support Joe Biden and does like and does support Donald Trump.
Okay, and so now, but they have also a dilemma because, and you write about this, that they want to preserve they want to preserve some of this, and so they have to sort of thread the needle so that they can say that. I mean, really, I mean, the long and short of it, in my opinion, is there's two things that they want to protect. They want to protect the Fed, and they want to protect trade. Everything else, they're basically willing to say to Donald Trump, yeah, go have at it. But they've got to be careful in the way that they rule in this case, because they don't want to rely too much on the major questions doctrine, according to what you've written. So they're trying to find sort of more technical ways in which they can sort of stop Trump from doing these tariffs, but still sort of reserve the pristineness of the major questions doctrine.
Yeah, I would add that to your list of things that the court wants to preserve: the Fed, trade, and their own power to strike down future Democratic policies that they don't like. So at oral argument, the liberal justices, you could tell they're like still pretty annoyed about how the student debt case went down. I'll just give one representative example. Sonia Sotomayor said to Trump's Solicitor General, "I don't understand your argument. Like, didn't we just say that the president, can't assert broad statutory powers under made-up emergencies?" And the Solicitor General tried to distinguish to say, education policy, that's domestic. Tariffs, that's foreign affairs. That's really, presidential power. And Sotomayor said, okay, so Biden could have just said that student debt was a global warming climate change crisis and he could have gotten his way. Now, the answer, of course not. She's being sarcastic. But the point is that she's showing that there's no real distinction here. The court just didn't like the policy in the student debt case and is a little more friendly to this president, certainly has been since he took office for the second time 9 months ago.
And so where are the conservative justices in terms of the way they apply it? Or how are they going to get, how are they going to how are they going to be able to serve their two masters of, one, maintaining their sort of wild card that they get to play, and two, also protecting tariffs?
Well, it is good news that, for once, the conservative justices at oral argument were a little more skeptical of Trump's position than they usually have been. And I think that goes back to your point, which is that the conservative justices do want Trump to have power, do want Republican presidents more generally to have power, but not when it can start interfering with sort of the traditional conservative legal establishment, Wall Street types. Like, they are beholden to that wing of the conservative movement as well. And I think they understand that if a Republican president kicks off a self-inflicted recession on their watch, that's bad for the Republican Party's electoral future. But what they need to do then is figure out a way they can dispose of these tariffs or roll back these tariffs without limiting their power in the future. So I'll give two examples. Brett Kavanaugh at oral argument said, look, previous presidents, they've never tried to impose tariffs under this law, IEEPA. So maybe that just suggests that, there's a common understanding that IEEPA doesn't allow presidents to do this. Sort of similarly, Amy Coney Barrett, she said, look, there are other federal laws that explicitly allow presidents to impose tariffs. This law, IEEPA, does not. So maybe we can just resolve it this way. I think the thing to understand here is that the major questions doctrine is not and never was, a rule that this court was going to apply even-handedly. You were never going to get John Roberts up there saying, well, look, we said student debt relief, that was a major question. So tariffs, this must be a major question too. No, the less they say about the major questions doctrine in the case, the better for them, because it preserves the most flexibility for them going forward of rolling back future sort of progressive policies that Democratic presidents might try out.
Okay, there's two things there I want to address. One being, and I know you just have a couple of minutes left here, but one being sort of like their whole sort of strategic and tactical way in which they're sort of reserving, like they're making decisions without really saying anything about them, so that they can't be sort of held to account down the road on some level. I want to get to that in a second, but just those two things that Kavanaugh and Coney Barrett, they're so desperate to address this in that matter. Like the idea, it seems to me, I mean, with Coney Barrett, the idea that like, emergency doesn't specifically call, but I mean, the nature of an emergency is like, we don't know what's going to succeed in that instance. And so you would imagine it's pretty broad what you can do to address an emergency. The real question, it seems to me, is this an emergency? Like, and are they in a position to make an assessment on the facts in the case? Like, would that be more of like a fact finding? Is there an emergency that would justify an emergency response?
This actually came up at oral argument as well. Like traditionally, the courts kind of defer to the elected branches as to, determining what an emergency is. But like, what a coincidence here that helps their favorite president. That's a point in his favor. And Justice Kagan brought this up at one point when the Solicitor General said, well, look, under the law, presidents, they have to formally declare emergencies. So that will prevent abuses of power going forward. And Kagan said, all this court has done for the last 9 months in 24 straight cases is give Trump what he wants when he asserts emergency powers. All we've done is say, yes, Mr. President, we are not going to second guess your declaration of an emergency here. So like that, you're right. That's not really a constraint on Trump's power. It's more just like kind of a box he has to check going through the motions. But no, like the justices aren't going to weigh in here and say, trade deficits aren't an emergency. Now, like they aren't. Anyone who's been alive for the last 50 years while this country's been running trade deficits probably doesn't think that this country has been in a half century straight of economic emergencies. So it's kind of like, if Trump's going to try it, then we move on to the next order question of, well, can we, the conservative justices, figure out a way to keep these tariffs, or can we get rid of them again for the sake of the Republican Party's electoral future?
All right, so let's move to the other part. They want to protect the major questions doctrine because the more that they write about how it works, the more it becomes something other than essentially a wild card that they can apply whenever they deem fit, because they're not bound by their own restrictions or contours that they've created for the application of that doctrine in the past. And they're doing the same thing in the shadow docket, right?
Right.
Yeah. Walk us just through that briefly.
Sure. So, the thesis of what I wrote is that the less the conservative justices say about the major questions doctrine, the better, because then they don't have to, potentially reconcile what they say in this case with the major questions doctrine next time they try to assert it, when President J.B. Pritzker tries to use executive power in some way that they don't like. Now, there's also a possibility, and this gets like a little in the weeds of how the court works, but it's like a time-honored Roberts trick, so I want to bring it up. There's also a possibility that a conservative justice tries to write an opinion that, strikes down or rolls back Trump's tariffs under the major questions doctrine to try to get the liberal justices to sign on to it, to endorse the major questions doctrine. And this is something that John Roberts in particular loves doing. He's done it in a lot of the court's voting rights cases. He's written sort of narrow technical opinions that a liberal justice or two will sign on to. And then later, when he uses that case to, roll back significant chunks of the Voting Rights Act, he'll say, well, look, this court's, this court across ideological lines said this just a couple years ago. So what are my liberal colleagues so upset about? But the point is, either way, whether the justices don't say anything about the major questions doctrine, or whether the conservatives try and, get the liberals to endorse it. They're not going to do anything in this case that takes away their future power to interfere with Democratic policies. And that's why you saw the Republican justices spend so much time at oral argument talking about these very technical off-ramps sort of for getting rid of this case in a way that, that wouldn't cast aspersions on something even like their student debt case from 2 years ago.
Just another example of how these guys are basically working backwards, it seems to me, from how they want to rule on something and then sort of backfilling it with some type of rationale. Jay Willis, editor-in-chief of Balls and Strikes. We'll put a link back to your work in that piece. Really appreciate you coming on and talking to us about it.
Thanks, y'all, so much for having me. Appreciate you.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.